employment opportunity. What is equal employment opportunity? EEO is the condition in which all individuals have an equal chance for employment, regardless of their race, color, religion, sex, age, disability, or national origin. The EEOC, or the Equal Employment Opportunity Commission, is responsible for enforcing federal laws that make it illegal to discriminate against a job applicant or an employee because of the person's race, color, religion, sex, including pregnancy, gender identity, and sexual orientation, national origin, age, 40 or older, disability, or genetic information. It is also illegal to discriminate against a person because the person complained about discrimination, filed a charge of discrimination, or participated in an employment discrimination investigation or lawsuit. This presentation is going to focus on the Pregnancy Discrimination Act of 1978. This was an amendment to Title VII of the Civil Rights Act of 1964. The Pregnancy Discrimination Act of 1978 defines discrimination on the basis of pregnancy, childbirth, or related medical conditions to be a form of illegal sex discrimination. According to the EEOC, this means that employers may not treat a female applicant or employee unfavorably because of pregnancy, childbirth, or a medical condition related to pregnancy or childbirth. The EEOC versus the Peninsula Packaging Company. A press release located on the EEOC.gov website. In Fresno, California, Peninsula Packaging settled to pay $45,000 and provide other relief to settle a charge of pregnancy discrimination filed with the U.S. Equal Employment Opportunity Commission. The charge made to the EEOC alleged that a packer required a modification to her job due to her pregnancy, which Peninsula Packaging refused to do. Instead, the company placed the employee on an involuntary leave of absence. The EEOC investigated the allegations and found reasonable cause to believe that Peninsula Packaging discriminated against the employee due to her pregnancy, in violation of Title VII of the Civil Rights Act of 1964 as amended by the Pregnancy Discrimination Act. Without admitting liability, Peninsula Packaging agreed to enter into a 3-year consultation agreement with the EEOC and the alleged victim, thereby avoiding litigation. In addition to the monetary relief, the company agreed to hire an outside equal employment opportunity consultant to develop and conduct effective training for all employees on discrimination with an emphasis on pregnancy discrimination, develop reporting procedures, and assist the company with revising and modifying its current discrimination policies. The EEOC will monitor compliance with this agreement. Employers have an obligation to provide an accommodation to a pregnant employee, particularly if they are providing the same accommodation to other employees, said Melissa Barrios, director of the EEOC's Fresno's local office, which includes San Benito County and its jurisdiction. We commend Peninsula Packaging for working with the EEOC to resolve this charge and for implementing measures intended to prevent discrimination in the workplace. According to the company's website, www.peninsulapackaging.com, Peninsula Packaging provides design, development, and the production of packaging for consumer-ready produce, bakery, deli, and other on-the-go food items. A similar case that I located was the EEOC versus R. Siskin and Company, Inc. The Siskin Group was ordered to pay $50,000 to settle the EEOC pregnancy discrimination suit. A Manhattan-based apparel company in New York, doing business as Siskin Group, was to pay $50,000 and implement revised anti-discrimination policies and procedures to settle a pregnancy discrimination lawsuit filed by the U.S. Equal Employment Opportunity Commission, the federal agency announced today, on 11/29/17. According to the EEOC's lawsuit, Siskin Group fired a customer service employee because of her pregnancy, childbirth, and related medical conditions that include the effects of an emergency cesarean section. Although Siskin Group purported to grant the employee maternity leave, when she tried to return to work, she was informed that she no longer had a position for reasons that the EEOC said were pretext for discrimination. Such alleged conduct violates Title VII of the Civil Rights Act of 1964 as amended by the Pregnancy Discrimination Act, which prohibits employers from discriminating based on pregnancy, childbirth, or related medical conditions. The EEOC filed suit in July in the U.S. District Court for the Southern District of New York, after first attempting to reach a pre-litigation settlement through its conciliation process. The consent decree resolving the suit was entered by U.S. District Judge Catherine B. Forrest on November 27th. It provides that Siskin pay the $50,000 in lost wages and damages to the former employee. The decree also requires multiple steps to prevent future discrimination, including anti-discrimination policies, training, and leave and accommodation procedures, which will be monitored by the EEOC for 3 years. In a statement made by EEOC Regional Attorney Jeffrin Burstein, he stated, "We are pleased that because of this settlement, Siskin Group will institute policies and provide training so that its management will better recognize and protect the rights of women in the workplace going forward." EEOC New York District Director Kevin Berry added, "This case exemplifies the EEOC's commitment to enforcing the law's protections for women in the workplace, including pregnancy and childbirth." The EEOC advanced opportunity in the workplace by enforcing federal laws prohibiting employment discrimination. More information on this is available at the www.eeoc.gov website, where you can stay connected with the latest EEOC news and also subscribe to their email updates.